Welcome everybody to the Urban and Community Forestry Society Learning Series. Just going to give us just say a few words about what we're going to be doing today, and then I'll be introducing our speakers. Today we'll be hearing from James Corman. He's going to be talking about successful and unsuccessful constitutional challenges to the urban tree protection laws in the U.S. courts. So we're really excited to have him. And we're really grateful to our sponsors, Ecoscene and Planet Geo. Thank you to them. Without them, we wouldn't be able to do our learning series. So thank you so much. Just a few things about today. Like I put in the chat just a minute ago, please drop your name in, where you're from, introduce yourselves. We'd love to hear who you are and where you're calling in from. Just so you know that this webinar is being recorded, and we will be having CEUs at the end of the webinar. I will be posting a form that you can submit your ISA information. And then we will submit for ISA CEUs on your behalf. Throughout this webinar, please keep yourself muted. You can turn your camera off if you want during the presentations. At the end, you'll be able to come off mute and camera and ask some questions to our speakers. And feel free to use the chat. If you have any questions, please let us know. I'll be monitoring the chat while we go. So a little bit about Urban and Community Forestry Society. We are a membership organization, and our mission is to build the confidence, competence, and camaraderie of all professionals who manage trees and forests in cities. And we've been around since 1964. Like I mentioned, we are a membership organization made up of people like you. We have members from all over the world. And we're also a professional affiliate of ISA. And so when you're renewing your ISA membership, you're also at the same time able to join and become a member of SMA. We hope that you will. So a little bit about the members at UCFS. We are professionals who make tree planting and care decisions every day in our communities. And so we range from private companies, nonprofit organizations, people who work for municipalities and state and city governments. And we're here to serve you. And you are our members, our colleagues, and our friends. Some of the benefits that you would get as a member, and that many that's open to everyone, is our City Trees publication that comes out twice every other month. And many of our other programs, our Arborist Exchange, Mentorship Program, I'll go into a little bit more detail about all of them. But these are just some of the things that we do for you. One of the big things that's coming up right now is our mentor program. The open cycle is going to be starting in October. So if you've ever considered wanting to have a mentor yourself, if you're looking to make some career decisions or find yourself at a crossroads and just want to talk that through with somebody, you can join our mentorship program and we'll pair you with a mentor. Or if you're interested in actually mentoring someone else in the urban forestry profession, you can have that opportunity as well. So please consider applying to be a mentor or a mentee, and you can keep an eye out for that. It'll be coming up in the next couple of weeks. Our annual conference is coming up this year in Chicago. It'll be also a part of the Arbor Day Community Forestry, Partners in Community Forestry Conference. And so if you're interested, please, we hope to see you in Chicago. Many of you have heard of the Municipal Forestry Institute. That leadership training happens every year in February. This year, we're going to be in California in the Santa Cruz area. If you know someone who's interested in advancing their profession, their career, becoming more of a leader in urban forestry, we encourage you to apply. Applications will be accepted through October 1st. So if you are interested or if you know someone else is interested, please apply. Coming up in our learning series next week, we're going to be having a panel discussion with some of our frontline workers in the EAB that have been treating and managing emerald ash borer throughout the country for decades now. And so we have a great panel of 5 people that are going to be joining us and talking about their experience, what worked for them, what challenges they saw, and how they can help advise those of us who are finding EAB in our communities today. And then in October, we have, and that webinar is free for members. And then in October, our next webinar series is about the city of Mississauga is going to be talking about their experience managing the backlog of stumping that they had and how they managed that successfully. So please consider joining us today. Become a member of UCSF. I'll put some links in the chat here in just a minute. Before I do that, I want to introduce, here, I'm just going to stop sharing my screen. I'd like to introduce John O'Neill. He's our resident lobbyist, we like to call him. He's the lead forester for the Department of Transportation Urban Forestry Division in Washington, D.C. And John, please.
Thank you, Carla, and thank you everyone for being here and for giving me your attention for just a moment before I turn you over to James. Now, I could say of James Komen what Philario says of Posthumus in Shakespeare's Cymbeline, which is, "Be better known to this gentleman, whom I commend to you as a noble friend of mine. How worthy he is, I'll leave to appear hereafter rather than story him in his own hearing." But I don't want to say that, in fact, because I do want to story James Komen in his own hearing. That means sing his praises even when he's present. After graduating from the best public high school in probably the country, he started working as a consulting arborist while at night studying law at Loyola. And from there, he plunged headfirst into learning everything there is to know about tree law. Tree law, to the extent that it's a field of law, is a multidisciplinary study of all sorts of types of law, like torts, constitutional law, property law, civil and criminal procedure. And James has been deep in all of it, collecting over 3,000 tree law cases from across the United States and studying them to see what can be learned. And if you've heard of him at all before, it's because you've seen him speak or disseminate all the knowledge that he's collected through the course of his studies and research. And you'll know that he's a fantastic public speaker. So without further delay, I'd like to turn it over to my friend, fellow tree lawyer, and the man who's always the smartest person in the room, James Komen.
You're very kind, John. Thank you. Let me pull up my share screen. Can you see that?
Yep, we can see it. Thanks.
All right. Our story begins today in the year 1772. This is before the United States became a country. We find ourselves in the town of Weir, New Hampshire, a little forestry town with a lumber mill. Now, at that time, New Hampshire was one of the British colonies, and as you may know, the British Empire very much valued its navy. To build all those ships it needed to maintain, it needed a lot of wood. And so in order to preserve this valuable resource in the New World, the British government passed the Pine Tree Act. It declared that all trees 12 inches in diameter or larger shall be preserved, and any man cutting down a pine tree greater than 12 inches in diameter shall be guilty of a crime. Well, one day, some British officers were poking around the sawmill in town, and they saw some logs that had the mark of the crown. They immediately charged the owners of the sawmill with the crime of violating the Pine Tree Act and carted them off to jail. The owners of the sawmill were none too pleased. Same with the residents of the town. See, they felt it was really unfair. How could the British government just claim their trees as their own? That's not okay. And so the townsfolk got together, and in the dead of night, on the eve of trial, they broke into the quarters of the British officers and savagely beat them with switches, one lashing for every tree that was claimed by the crown. And they ran them out of town. And standing there on the edge of town, waving their pitchforks and fists in the air, those townfolk thought to themselves, we are never going to let the government tell us what we can and can't do with our trees again. True story. It's called the Pine Tree Riots of 1772. This story sets the stage for the state of mind of the early founders, our founding fathers, when they ratified our Constitution. Well, the rest is history. Of course, the Revolutionary War, 1776 was the Declaration of Independence. Shortly thereafter, our 13 colonies became states. They got together, they ratified the United States Constitution, and shortly after that, they ratified the Bill of Rights, the first 10 amendments to the United States Constitution guaranteeing protection of individual freedoms from government overreach. Now, throughout our nation's history, literally from the very beginning, trees have been the subject of litigation. Some have wanted to preserve trees, others, well, they wanted to cut them down. Tree protection ordinances have been the subject of litigation for many, many years. And many folks have made different constitutional challenges to these ordinances, claiming that they are in violation of the highest law of the land. Some of these challenges have succeeded, others have failed. Today, I'm going to give you a small sampling of some of the cases that have discussed the constitutionality of tree protection ordinances. Here is just a brief sprinkling of challenges that I have seen in the research that I've done to the tree protection ordinances. And yeah, we're going to talk about a little bit about each one of these challenges. So the first case today takes place more than 100 years after the Pine Tree Riots. We find ourselves back in New Hampshire, but now we are in the town of Hinsdale. This is more than 100 years later. The Revolutionary War is ancient history. The Civil War was 2 generations ago. Now, the town of Hinsdale was a rural community. They had rolling hills and little farm roads lined with trees. And the townsfolk, well, they wanted to keep it that way. They loved the aesthetic and the beauty of having tree-lined streets. And so, in the interest of preserving the status quo, they passed a tree protection ordinance. They said that the town forester shall go forth and tag the trees within the public right-of-way. And any tree that is tagged by the town forester shall not be cut down under penalty of a crime. Well, Mr. Whitcomb happened to own some property fronting a public highway, and he discovered some tags on his trees. When he found out what those tags meant, well, he was none too pleased. See, he didn't like being told what he could and could not do with his property, so he promptly went and chopped them all down, stacked the wood next to his house for firewood. Well, of course, town forester, Mr. Bigelow, found out, and he said, "Whitcomb, you just broke our ordinance. I'm going to have to write you a fine." Whitcomb said, "Blow it out your ear. Those are my trees. I'll do what I want with them." Bigelow says, "I don't think you understand. See, we're the township, and we passed an ordinance that says you can't just go cutting down trees like that. These are in the public highway. They provide benefits to the public. This is very important, and that's why we passed the rule. You are going to have to pay for the damage that you have done to this public resource." Well, clearly, these gentlemen couldn't come to an agreement. Whitcomb believed that the charge was full of garbage. So he took it all the way up to the New Hampshire Supreme Court. And the New Hampshire Supreme Court considered this issue, and they decided that to prevent a man from using his own property is virtually taking it from him. They equated the situation with the government coming and chopping down Mr. Whitcomb's trees and then using the wood for road repairs, which unquestionably would have been a taking. But here, instead of chopping down his trees, they just simply tagged them and said, you can't chop them down yourself. The court said that the trees belong to the owner of the adjacent land, Mr. Whitcomb, who cannot be deprived of his right without compensation. They said that because the township never paid Mr. Whitcomb for his trees, they never went through with an eminent domain proceeding, the proper legal procedure for the government to take property, well, they never acquired an interest. And because they never acquired an interest, they couldn't fine him for the chopping of the trees. And thus, they took the charging documents, ripped them to shreds, and Mr. Whitcomb got off scot-free. Similar set of facts, stepping backwards in time a little bit to 1871 in New York. The town of Lancaster also had a tree protection ordinance. Mr. Richardson owned a single-family residence in town with a lovely white picket fence and a street tree out front. Now, Mr. Richardson, he didn't much like this tree out front. It dropped leaves, it was annoying, and who knows, maybe one day it might even fall and kill him. So he decided that he was going to chop it down. Well, again, the town forester didn't take kindly to that. He said, "Yo, Richardson, you violated our tree protection ordinance. You're going to get hit with a fine." Richardson challenged him and said, "Go pound the sand. I'm not paying no fine." And off to court they go. And the Intermediate Court of New York said that a law that would place trees under the care of public officers would be a very wholesome exercise of legislative power. In other words, the court loves the idea of a tree protection ordinance. After all, trees are providing benefits that are common to all, not merely the owner of the land on which they grow. However, before the public can say that a man cannot cut down his own trees, they must have acquired an interest therein by purchase or by the right of eminent domain. This the city did not do. And because the city of Lancaster never paid Richardson, Richardson owned his trees and he could do with them as he pleased, including chopping them down. Again, Mr. Richardson got off scot-free because of this Fifth Amendment challenge, a takings challenge to the tree protection ordinance. In both Bigelow and Lancaster, the tree protection ordinance was declared unconstitutional. Whew. We're now going to spring forward yet another 100 years. This is a very recent case. This one takes place in the township of Canton, Michigan. FP Development was a developer, and they owned a commercial piece of property that they intend to turn into a strip mall. Unfortunately, it was burdened by a bunch of pesky trees, so they immediately got to work clearing the lot. Unfortunately for them, the township of Canton had a tree protection ordinance, and when the city forester found out about FP Development's land clearing, they immediately ran out there and slapped FP Development with a stop work order. In other words, stop all work, and you cannot legally do any work on this property until some conditions are met. And the primary condition that they had was you have to pay the fee. The fee was approximately $250 per tree for the 100-so trees that FP Development had chopped down, amounting to whatever it was, $25,000, something like that. So FP Development, with this bill and this stop work order, well, they were none too pleased. They said, "No, you can't do that to us. You can't just tell us that we're not allowed to use our lot. You are holding up construction. You are costing us millions of dollars. No, we're not going to take this lying down." They sued. They sued the Charter Township of Canton, and they claimed that the tree protection ordinance was unconstitutional. They made 3 challenges. Let's take a look at each of them in turn. The first challenge that they made was that the tree protection ordinance violated the Fourth Amendment. Now, the Fourth Amendment preserves the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Well, FP Development argued that their trees had been seized by the township by claiming that they weren't allowed to chop them down. After all, the Canton was asserting control over their trees. And it was unreasonable because they were completely preventing all development of the property, because you can't put in a strip mall if you don't clear some trees. So FP Development says, no, this is in violation of our Fourth Amendment constitutional rights against unreasonable searches and seizures. Canton said, I don't think that's how the Fourth Amendment works. So they presented their case to the Sixth Circuit Court of Appeals. And the Sixth Circuit Court of Appeals broke it down logically. And they said, all right, well, what does the Fourth Amendment apply to? Well, it applies to persons, houses, papers, and effects. Trees are not people. Trees are not houses. Trees are not papers. So we can cross those off. If anything, they would have to be effects. But we know from case law that effects are tangible personal property that can be moved around from place to place, things that you hold with you, like a purse or a backpack. And trees aren't that. So because trees are not effects, the Fourth Amendment just really doesn't apply at all, because persons, houses, papers, and effects are the only things that are protected by the Fourth Amendment. So maybe it does provide great individual freedom protection, but it doesn't apply in this case. Undeterred, FP Development then pulled out their next argument. The Eighth Amendment. The Eighth Amendment says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This excessive fines clause of the Eighth Amendment is designed to keep the government from overreaching and extracting unreasonable payments from somebody who is charged with a crime. The idea is we don't want the government to make money off of criminals. That's something that we thought was a very fundamental right that we didn't want to be violated when we passed this Bill of Rights. So FP Development argued that this $25,000 fine, $250 a tree, was excessive. They said that it was an excessive fine in violation of their Eighth Amendment protections. But Canton said, yeah, but that $250 is so that we can plant another tree. Like, the whole point of this is to remediate the harm that you've caused by wrongfully cutting down trees. Sixth Circuit agreed. They said that the purpose of the Eighth Amendment is to limit the government's power to extract payments as a punishment, but the tree replacement fine is remedial, not punitive. It is not a punishment. It is just simply money to put things back the way they were, to undo the harm that had been done by FP Development. And thus, it ruled that the Eighth Amendment was not implicated here, because clearly the $250 per tree was remedial in nature. It was just undoing the harm. It was not slapping FP Development with some sort of a punishment. All right, well, now FP Development was getting a little nervous. So they pulled out the big guns. They pulled out their best tried and true argument that had a long history of acceptance by the courts, the Fifth Amendment. The Fifth Amendment. Now, before I give you their argument, I need to give you a little bit of background on something called exactions. So exactions have been thought of as legal extortion. Essentially what it is a government, a city government, can force you to pay money or do a thing if it remediates some negative impact of your proposed development. They can say, we're not going to give you building permits for your Chick-fil-A because we're concerned that you're going to cause a snarl in traffic at the intersection until you either pay a traffic mitigation fee or you pay to put in a turn lane or a stoplight. The idea being, if your Chick-fil-A is going to cause harm to everybody else's public interests, they can extract a payment to hopefully mitigate those harms. However, you go above and beyond, the city or township goes above and beyond what they can permissibly do under the doctrine of exactions if there's no rational relationship and rough proportionality with the thing that they're trying to remediate. So in this case, FP Development argued that this fine had no rational relationship. And Canton said that's ridiculous. That's totally ridiculous. See, you cut down trees. We are trying to plant new trees. Okay, we are undoing the harm that you've done. You cut down some trees, we plant some more trees. There's your rough proportionality. How is this a violation of the Fifth Amendment? And FP Development took a deep dive into Canton's ordinance, and they looked specifically at the statement of purpose, that little sentence that begins most ordinances that most people just skip over and don't even bother reading. And it said something along these lines. It said something like, we believe that trees are important because they mitigate the negative effects of erosion, and they mitigate a heat island effect, and they improve property values of adjacent properties. Something along those lines. And therefore, we hereby protect the trees. So FP Development said, well, the reasons that you guys gave are erosion, heat island, and property values. But if you can take our money and plant replacement trees somewhere else in the city, well, you can just plant them 3 miles away. A tree 3 miles away is not going to mitigate the negative impacts of dust or erosion or property values or heat island. That's not going to change anything. So really, there's no rational relationship at all between planting these off-site trees and the trees that we're removing here. And thus, because there is no rational relationship, you cannot impose a fine and you cannot impose the stop work order. Canton was flabbergasted, but they presented their case. They said, all right, Sixth Circuit, we have an ordinance. When somebody removes the trees, they got to pay for their mitigation fee. We got a rational relationship. We got a rough proportionality. This is not a violation of the Fifth Amendment. And the Sixth Circuit carefully considered the issues. They said that Canton may not leverage its legitimate interest in mitigation, in other words, planting trees, to pursue governmental ends that lack an essential nexus and rough proportionality to those impacts. This is a doctrine of Fifth Amendment exactions. This is repeated in the case law for many, many years. Essential nexus, rough proportionality, those are the key words. And the idea is, well, the essential nexus is we're planting trees, the rough proportionality is $250 a tree. The Sixth Circuit disagreed, though. They said that tree removal triggers the mitigation requirements regardless of the specific impact caused by their removal. And Canton failed to show in this case that tree removal affects a certain level of environmental degradation on the surrounding area. Now, you might be thinking, well, what the hell? Like, of course, you cut down trees, it's going to make the environment worse off. Well, the trouble is here, Canton hung its hat on, we have an ordinance, it says don't cut down trees. If you cut down a tree, it's $250 a tree. They didn't bring any other evidence to the table. They didn't bring any other evidence of the wonderful things that trees do. And because they failed to bring that in this case, the Sixth Circuit ruled that Canton's tree ordinance, as applied to FP development, was an unconstitutional condition. All right. Let's take a moment and appreciate what just happened, because some of you are looking at this date, 2021, you're thinking, really, this happens in present day? Yes, but first of all, the most important thing that I want to point out about this holding is it's an as-applied challenge. It is not declaring that the whole ordinance is invalid. It is not saying that. What it is saying is the way it was applied to FP development was unconstitutional, because they didn't actually make any findings of the negative impacts of FP development's tree removal. Maybe trees generally provide benefits, but they didn't actually show how removing these trees harmed the community. And in absence of that showing, they didn't have that rational relationship, that essential nexus. And the other thing that they said was they did not hold that the fine was unconstitutional. Canton is free to impose that remedial fine to say if you chop down a tree, you pay us some money to plant trees elsewhere. We've established that part's okay. The thing that they can't do was the stop work order. They said, we're not letting you build until you pay the fine. And that's where they violated the Fifth Amendment. What they were perfectly able to do was fine them and let the development continue. And that's ultimately what ended up happening. What they were perfectly fine doing was collecting it at some future point. They just couldn't condition development on payment of that fine. That's where they went astray. And if they wanted to enforce the payment of the fine with a stop work order, they needed some more evidence in the record that would show that with that money, they would be mitigating the negative impacts of the cutting of the trees, and that they did not do in this case. So let this case be a cautionary tale for all my urban foresters out there. Remember to be able to, I know you're standing on a soapbox every day doing this, but remember to bring evidence to the table of why these trees, when somebody violates an ordinance, why these trees were providing benefits to the community that need to be remediated. That's very, very important. All right. So the next case that I want to present is one of my favorites. This one's a little bit fun. We find ourselves, we're going to go back in time a little bit to 2013 in Montebello, New York. So Mr. Novi is a fairly well-to-do individual, and he was very happy because he just bought a very nice estate in the well-to-do neighborhood of Montebello. Now, if you go around Montebello on Google Street View, or maybe you live in the area and you've been there, there's a lot of large lots, great big mansions. Some of them have big lawns in front, but all the properties are bordered by trees, and some of them are completely covered with forest. So clearly the community loved its trees. In order to preserve the forest-like appearance of Montebello, they passed a tree protection ordinance that said, don't cut down the trees without a permit. Pretty simple. Well, Mr. Novi, he bought his home, and his one dream in life was to have a lawn. So he got to work. He was very industrious. He pulled out his chainsaw and he started clearing some trees. He didn't get too far when somebody ratted him out, and the urban forester from Montebello came out and said, "Yo, Novi, what you doing?" Novi stopped his chainsaw. He said, "Making myself a lawn." The urban forester said, "You got a permit for that?" Novi says, "I don't need no permit." Well, the urban forester said, look, you're cutting down trees. We got a law that says you can't cut down trees. I'm going to have to fine you. Novi says, I'm going to have to fine you. He said, look, I'll just take this ticket. I'll rip it up. I won't fine you if you just promise not to cut any more trees. Can you just agree to that? Novi says, man, it doesn't have to do. He finally agrees. Urban forester goes away, rips up the ticket. Novi goes inside for like 10 minutes. As soon as the urban forester's gone, he goes back out and clears his lot and puts in a lawn. Of course, the urban forester finds out about this, and he is none too pleased. He slaps Novi with everything he's got. He throws the book at him. And Novi, being somebody who firmly believes in property ownership rights, he fights back tooth and nail. And bless his little heart, he must have picked out a constitutional law textbook from law school and leafed through it and found literally every argument he possibly could, attenuated or not, that could claim that the tree protection ordinance in Montebello was unconstitutional. This opinion was so entertaining to read. I literally got out a bowl of popcorn and I was munching on it as I was reading this. It was hilarious. Here is just a small sampling of some of the arguments that Mr. Novi made. All right, first, he argued that the tree protection ordinance was in violation of his 14th Amendment rights. Now, the 14th Amendment covers a number of different doctrines, but first he claimed that the 14th Amendment provides protection to due process. After all, it says no state shall deprive any person of life, liberty, or property without due process of law. The idea being you don't want just someone to get thrown in jail without an opportunity to be heard or maybe present their defense. That just wouldn't be fair. The 14th Amendment is designed to prevent overreach of the state governments. There's a procedural aspect, there's a substantive aspect. The procedural aspect is, did you have an opportunity to be heard, and was it proportionate to the amount of harm and the risk of erroneous deprivation? And then the substantive element has to do with totally arbitrary and capricious actions of the government. Again, just severe government overreach. We don't want the government to be taking fundamental rights from people. That's a violation of the substantive due process rights under the 14th Amendment. And so Mr. Novi argued that his trees had been taken from him without any procedural safeguards. They just simply passed an ordinance and said, oh, you can't chop down your trees. And Mr. Novi didn't like that. He didn't have any say in that. And all of a sudden, now he can't chop down his trees? Clearly, that is a violation of his procedural 14th Amendment rights. And substantively, well, I mean, I've got a right to do what I will with my property. That sounds pretty fundamental to me, doesn't it? The New York court didn't see it his way. They said that the tree ordinance clearly provides for adequate process, which the defendant, Mr. Novi, has chosen not to pursue. You see, in the Montebello Tree Protection Ordinance, it says, if you don't agree with the fine, follow these procedures to appeal it. He didn't do any of that. The only thing that he did was he went directly to the courts and tried to overturn the ordinance. So the court, they didn't say, oh, the tree protection ordinance's due process is fine. They said, because you didn't follow the procedures, we're not going to address your argument. So it left the door open to the possibility that a tree ordinance could be overturned on the basis of not giving sufficient procedure, an opportunity to be heard under the circumstances before a deprivation. But in this case, nobody didn't follow the procedures at all, so he can't complain. And then second, they said, and the substantive aspect of it, they said the ordinance is not so outrageously arbitrary as to constitute a gross abuse of government authority. They're just simply telling you not to cut down trees because the trees are providing benefits common to all. So his 14th Amendment due process challenge did not succeed. But undeterred, Novi said, all right, well, the 14th Amendment also provides protection for equal protection under the laws. The next clause of the 14th Amendment says that no person shall be denied the equal protection of the laws. You see, I don't have a lawn. My neighbors have lawns. They were allowed to make lawns. I am not allowed to make a lawn. Clearly, we are being treated differently. We are being treated unequally under the law between people that have lawns and people that don't have lawns. Thus, my 14th Amendment rights to equal protection of the laws have been violated. Again, the court looked down its nose over the top of its glasses at Mr. Novi and said, dude, that's not what the Equal Protection Clause is for. unless a suspect class, think race, creed, religion, or a fundamental right, think the right to get married or the right to have kids, is involved, classifications that create distinctions between similarly situated individuals will be upheld as long as they're rationally related to a legitimate government interest. Here, the legitimate government interest was preserving the trees for protection of the environment, the shade, and the benefits common to all. Mr. Novi is not a member of a suspect class. He's not claiming he was discriminated on the basis of race or gender. He's claiming he was discriminated on the basis of whether he had a lawn or not. So he is not a member of a suspect class. And a fundamental right, the right to have a lawn is not a fundamental right. So again, the court threw out this challenge to the tree protection ordinance. Now, there were a number of other challenges, but I had to present this next one to you. I admit, when I was reading this case, I did not have this on my tree law bingo card. Mr. Novi made a First Amendment freedom of speech challenge. He argued that putting in a lawn was a form of expression, very similar to painting a picture, putting on a play, or reciting a poem. He said that by forcing him to retain those trees, he could never have the true lawn that he always dreamed of. He would never be able to express himself in the ways that are essentially protected by the First Amendment. And after all, artistic expression, whether written or visual, is clearly protected by the First Amendment. But the court said, yeah, but you haven't shown that your desire to landscape amounts to artwork that is a quintessential form of expression. This is just a landscaping project. So take note of what the court did here. It slams the door, but then opens it up a crack. It does not say that a tree protection ordinance can never be invalid under the First Amendment. It does not say that. It says that it's not invalid under the First Amendment here. But theoretically, somebody could mount a challenge, and if they brought enough evidence to the table that their desire for freedom of expression is enough to be able to justify protection under the First Amendment, it is theoretically possible that someone could be successful in a claim against a tree protection ordinance. I would keep an eye on this argument. It was made in 2013, and it's possible that another one of these cases may develop in the coming decade. The last case I'm going to give you is a little more serious. So this one this is the last case. It takes place in New Jersey. Another recent case, 2009, New Jersey Supreme Court. So you better pay attention because this is the Supreme Court that's talking. And this is the New Jersey Shore Builders Association versus the Township of Jackson. Now, the Township of Jackson has a tree protection ordinance, and they said that if you cut down a tree, you gotta pay to put it back. You gotta either replant on the subject property, or if you can't do that because you've used up all the buildable area, then you gotta pay a fee that ends up planting trees off-site somewhere else. Well, the New Jersey Shore Builders Association was a group of developers in New Jersey, and they did not like tree protection ordinances generally. In fact, they were really sick of tree protection ordinances in a lot of different townships and cities, and they decided they were going to pool their resources and do something called a test case. What they did was they singled out the Township of Jackson, but their goal was to apply this to many different municipalities throughout the state. They just wanted to show that their argument would work in this particular case. And they sued the Township of Jackson under what's called a declaratory relief action. They're asking the court to declare something, and in this case, they're asking it to declare that the tree protection ordinance is unconstitutional. All right, so they mounted a number of different arguments. I'm going to be talking about two of them. So as I said, the Township of Jackson says if you chop down a tree, you got to be able to plant one on the subject property. If you can't plant one on the subject property, then you got to plant it off-site. And pay to plant off-site. They encouraged people to plant on-site. The mitigation fee was lower for on-site and higher for off-site, but sometimes just you can't fit it onto the subject property, and so they provided that alternative for putting the trees elsewhere. So now the New Jersey Shore Builders Association, they looked at their at the township's ordinance, and they said, "You can't do that. You can't do that. That's not okay. That is an overreach of the police power. So a moment on the police power. The doctrine of police power is not referring to the dudes wearing blue with badges and holding nightsticks. What we're referring to more broadly is the power of the government to regulate for the public health, safety, welfare, and morals. In other words, basically the fundamental idea of passing laws for the greater good. So of course, the police power is something that's inherent in the government. And the Township of Jackson is acting with the state of New Jersey's power within its borders when it passes ordinances. Of course, the Township of Jackson has police power. That part is not questioned. But what New Jersey Shore Builders is arguing is that they overstepped. They abused this police power by passing a tree protection ordinance. And this tree protection ordinance that's requiring these off-site mitigation trees. So their police power argument was that all police power legislation, that's the laws that are passed, is subject to the constitutional limitation that it not be unreasonable, arbitrary, or capricious. So the township says, okay, go on. We're not arbitrary or capricious. We're just asking you to replant after you cut down some trees. And an ordinance is not invalid because it would have done more to combat the evils which it seeks to address. Okay, that makes sense. Like, we're not going to say that it's illegal or an ordinance is invalid simply because it didn't do enough. As long as it does something and it's rationally related to a legitimate government interest, we have to uphold that. That part makes sense. But where the New Jersey Shore Builders Association says that they went wrong was they said, if you plant 3 miles away, that's not mitigating the negative impacts of dust, erosion, property values, because a tree that's 3 miles away isn't doing jack for this property right here or the properties immediately around. And because there is no rational relationship between the two, it's a violation of the police power. It's arbitrary and capricious. Well, the New Jersey Supreme Court thought long and hard about this. And they held that removal of trees on any property affects the health, safety, and general well-being of the inhabitants. This we can agree on. You cut down a tree, not only does it affect the subject property, but it also affects properties around it. And they said that replanting at the original location is optimal, obviously. However, where that's not feasible, the township mitigates the overall loss by planting off-site. In other words, you can't plant it on the site. We're going to put the trees elsewhere. But still, we are mitigating the loss of canopy, which is providing benefits to the city. And so as a result, the New Jersey Supreme Court they rejected the New Jersey Shore Builders Association argument of an abuse of police power because basically, in essence, they said, you can't say that the ordinance is invalid because it didn't do enough, because it didn't make them plant bigger trees or more trees or closer to the site. As long as it's doing something, it's perfectly fine. The next argument that they made was the taxation argument. They said, all right, well, a municipality has no inherent power of taxation. The state can tax, the federal government can tax, but Jackson cannot. This tree protection ordinance forcing us to pay money to plant trees somewhere else in the city amounts to nothing more than a tax, extracting money from innocent builders who are just trying to get on in the world and make the world a better place. Well, the New Jersey Supreme Court didn't like that argument either. You see, a fee imposed for a permit constitutes an invalid tax if its primary purpose is to raise revenue. But that's not what this fee is doing. What this fee is doing, much like in FP development, was so long as the replacement fees do not exceed the municipality's costs for administration and replacement, they're legitimate elements of the regulatory scheme. In other words, $250 a tree is enough to cover the replacement trees and maybe paying the urban forester to go out and administer the program. And as long as those fees extracted are less than the costs of remediating the harm and administering the program, then they're perfectly fine and they do not constitute a tax in violation of that doctrine. Thus, again, the New Jersey Supreme Court threw out the argument of the New Jersey Shore Builders Association, and they declared that the Township of Jackson's tree protection ordinance was perfectly constitutional. I saw one of the questions that came in before this course was, do you have any recommendations of text that we could use for a tree protection ordinance that's been held constitutional? Check out this case. You can pull up the text on Google Scholar, just type in the citation, and the case text actually copies a good portion of the ordinance from the Township of Jackson. So take a look at some of the language, and this language has been fully endorsed by the New Jersey Supreme Court. All right, so let's take a little review of where we've been and what we've seen so far. Bigelow v. Whitcomb, Lancaster v. Richardson, those were the street trees. And they said don't chop down street trees. And the court held that that's a violation of their Fifth Amendment rights because it's a taking to tell somebody that they can't cut down their own property. FP Development, they made 3 challenges: Fourth Amendment, Eighth Amendment, and Fifth Amendment exactions. Fourth Amendment was the search and seizure, but that didn't apply because it wasn't persons, property, papers, or effects. Eighth Amendment didn't apply because it was remedial in nature and wasn't a punishment. But the Fifth Amendment did apply because it was an unconstitutional exaction to force them to stop all work before paying a fine that they didn't actually provide the reasons for that remediation. People v. Novi made that the arguments of the 14th Amendment, due process and equal protection, and the First Amendment, my favorite, that one's near and dear to me. The First Amendment freedom of expression argument, neither of those were successful. And the New Jersey Shore Builders Association versus the Township of Jackson went up to the New Jersey Supreme Court, which rejected both of the challenges under the police power doctrine and the taxation doctrine. So we can see of all of the cases that we looked at, the only challenges that were successful were under the Fifth Amendment. All of the other ones failed for these cases. In Bigelow v. Whitcomb, Lancaster v. Richardson, and FP Development, the tree protection ordinance was held unconstitutional, or in FP Development, unconstitutional as applied. But in People v. Novi and New Jersey Shore Builders, the ordinance was held perfectly constitutional. All right, I hope you take some of the lessons from today, the stories that you've heard, back to your own towns, your own municipalities, and you read through your own ordinances and ask yourself the very, very important question from this talk: is your tree protection ordinance constitutional? Thank you, folks. I will now open it up for questions.
Thanks so much, James. If you have a question, you could start by raising your hand now, or you could throw the question in the chat.
While we are waiting for answers to come in, I think there were 4 questions that came in before the workshop even began. Let's see here. The first question was, are there constitutional private property tree ordinances that small cities with limited staff can use as a model? I would say I'm not going to state that something is perfectly fine, but I will say that the New Jersey Supreme Court gave the thumbs up to the Jackson ordinance, and a good chunk of its text is printed in the opinion, so you might give that a read. What are some legal penalties or incentives that can be applied to individual owners for the creation of tree protection areas? I think I'd be giving legal advice if I were to answer that one, so I'm going to decline to answer that question. What municipality are you aware of that has the most stringent tree protection ordinances? Well, gotta say, when John O'Neill presented on the DC ordinance, I was impressed. I was impressed. I think DC's up there, but I would also have to say that there's some cities out west in the Los Angeles area that have some pretty strict ordinances as well. And finally, the last question is, can a tree originating, when I say last question, I'm just mean of what's been preliminarily sent to me. Can a tree originating from a single property owner be fully protected by local ordinance from neighboring actions on trespassing features? And I think this actually addresses 2 different things. So I'm going to make a distinction. When we have a boundary tree or a tree that's over a property line, we actually have 3 interests at stake. One is the owner of the tree, one is the neighboring property owner, and one is the city, township, municipality. And all 3 of them have a say in what happens with this tree. So it may be possible that there are some protections afforded by the ordinance that even if the 2 owners agree they want to chop it down, it's still protected. It's possible that the ordinance doesn't apply, but one owner could still have his property rights protected under some other doctrine. but it would be too much to talk about those doctrines within the scope of this talk. If you want to learn more about boundary owner issues, I invite you to check out my other talk on who owns a boundary tree. You can find that either on my website or check out one of my upcoming presentations. All right, I see some hands in the air. John, the lawbarist, go ahead.
Thanks, James. Regarding, so thanks for the shout out, first of all, for Washington, D.C. strict tree laws. We have a component of our law, the Heritage Tree Law, that preserves trees over a certain size, 100 inches circumference, that can't be removed under any circumstance unless they're hazardous or an exempt species, basically an undesirable species like Ailanthus. So that obviously implicates the Fifth Amendment. When the law was passed in 2016, there was a part written into it that preserved the right of people to relocate trees. So even these heritage-sized trees, there's this sort of cottage industry in moving these very, very large trees in the District of Columbia. And the reason that was expressly written into law, from my understanding, is that it was a way to work around a Fifth Amendment takings challenge. There was never any made, so I don't know how effective that is. I think, and James can correct me or give me your opinion, but I think over time, like the viability of a Fifth Amendment challenge would decrease as properties continue to be used in a certain way over time. If people buy a property and there's already heritage trees on it, or if a tree grows into a heritage sized tree, then it's not really a taking to prevent someone from changing the use of that land that was already in existence when they obtain an interest in it. So just my thoughts on Fifth Amendment, how it applies to DC. And I think I preempted April's question. So,
John, I think that the idea of Fifth Amendment challenge came to me when you were presenting the DC ordinance, and I'm not going to opine on whether it is constitutional or not. That would be giving legal advice, and I'm not doing that right now. But what I will say is that was something that came to me, and it would be interesting to see if somebody mounts that challenge at some point in the future. But the distinction to make is, if the government takes a right that it did not already have, it's a taking. But if it's just simply requiring you to change the way you use property, it may do that under the police power doctrine. So depending on the circumstances, I could see an argument that's viable and an argument that's not. I guess it remains to be seen what cases we'll see in the future. I think I see another hand from, let's see.
It's April.
April, go ahead.
April, you want to come off mute and ask your question? Maybe while we're waiting for April, we've got a couple of questions on the chat. James, Drew asks, how much of case law is specific to each state? When one is looking for case law on tree protection ordinances, should we look in state first? And where does one find case law?
Well, a really good free resource is Google Scholar. You go there, and then there's actually a tab for case law, and you can type in your jurisdiction, and you can just Google things like tree or ordinance or tree ordinance or something like that. And sometimes just the scattergun approach is one way to first start out your research and see what's out there. I'll be candid with you. Some of my research just simply started with Google searching. But once you've gotten onto a chain of cases, what you can do is you can then follow those citations, because each case that you read is going to cite cases that came before, and you can back chain all of those citations. And now you've got a whole line of cases that you can read. And if you have a powerful legal tool like Westlaw or Lexis that you can use at your local legal library, then you can upchain it. You can see what other future cases that came after cite back to the one that you found. As far as tree protection ordinance case law in your jurisdiction, yeah, that's a good place to start. But as you can see, the case law that I've presented is from many jurisdictions. Law cases that are that come down through the Supreme Court of a state are controlling in that state unless they're overruled or abrogated by statute. And then the courts of appeals, the intermediate courts, would take next in line. But out-of-state cases are still useful, not as controlling authority, but what's called persuasive authority. In other words, you can say, look, court, you don't have to follow this, but here's what a sister state already thought through, and they dealt with a similar problem. You should come out this way as well. And so I think that there is value in looking at out-of-state cases as well. If you're just trying to get an idea of the contours of the doctrine, if you're just trying to get an idea of what's out there, I wouldn't bother limiting yourself to your jurisdiction. But if you were concerned about something that was state specific, something that's controlling in your jurisdiction, then yeah, you might want to take a look at that. But more importantly, what we're not doing here is we're not giving legal advice. We're just taking a look at what the contours of the doctrine are so that we can have an informed discussion about our tree protection ordinances, what we can and can't do. As far as actually applying the facts to the law, there's no substitute for good legal advice, and that would just be contact your local local attorney that's familiar with your case law. Drew, you actually have more parts to your question. I'm going to come back to this if we have time. I think I see a couple of other questions, but I'm happy to stick around as long as anybody, including you, would like to stick around. All right, Carolina, you said, do you have any examples of case law in Canada or where to look? Okay, this is a shout out to Julian Dunster. He actually wrote the book on tree law in Canada. And I believe you can get a copy right from the ISA website. So that's a really good book. Just pick up a copy, flip through it. There's a bunch of cases that Julian cites, and hopefully it'll give you a nice flavor for the law. But take note, Canada is based in English common law. And so Canada and the United States and Australia have common roots in English common law. So a lot of the same basic principles apply. In fact, every state except Louisiana has something in their civil code that says something to the effect of, if it's not stated in this law, then the law of this state is that of the English common law. In other words, they're saying that that's their floor, and everything that comes after that only modifies the English common law. So I think that, even if you're in Canada, reading cases from the United States is still, again, persuasive authority. It can be useful for showing how a case was resolved under certain facts in a certain jurisdiction at a certain time. All right, I see another hand, but it just says view all. If you have a hand up, go ahead and unmute yourself.
Yeah, let's try April again. Were you able to unmute yourself, April?
Yes, thank you. My question is about when fines are imposed because tree mitigation cannot be accomplished on site. We're exploring alternatives to tree planting for using mitigation funds, such as other projects that also have similar ecosystem service benefits. Do you think that's kind of a slippery slope, or do you think that if you can justify that something provides a similar benefit that aligns with your statement of purpose for the ordinance in the first place, that things like invasive species management or green infrastructure projects or other things that might be aligned with the benefits of trees could be justifiable uses of your mitigation fund?
When we're talking about whether the municipality has the authority to extract a payment, that's like an exaction that we were talking about with the FP development case. And it's okay as long as there's an essential nexus and a rough proportionality. But where you run afoul is where there isn't that relationship. So a good case that I didn't talk about today that addresses your question head on is, I just typed into the chat, Miramar Development Corporation versus City of Coppell. It's a Texas case. And in that case, they said that the city says, all right, you want to chop down some trees? Fine, pay us some money. And Miramar says, well, where are you going to put the money? And they said, oh, well, we're going to take this money and put it towards buying oak protection zones, to buy land to preserve oak trees. And we're going to use it to fund public education resources for preserving the trees in our town. And Miramar says, yeah, but both of those needs didn't change as the result of our development. The oak trees that are off-site still needed to be preserved just the same as before we chopped down the trees on our property. And the public still needed to be educated the same amount, whether we chopped down our trees at all. And thus you weren't actually mitigating the negative impacts of our development. And the Texas court agreed. They held that tree retribution fee in that case was unconstitutional. So the line, the demarcation is, if you use the money to put back trees, if they use the money to undo the harm that is being done by the development, by the tree cutting, then it's okay. But if you use the money to do something else that isn't actually offsetting that, it doesn't have that essential nexus or rough proportionality, then it could potentially be held unconstitutional.
Just want to give a shout out. We're just past the hour, so I know if anyone needs to leave. I did get someone mentioned that the CEU form is not accepting applications, so I'm trying to fix that. Keep the link. Hopefully I'll get it to work. If not, I'll be sending out an email with the link again if you're not able to fill it out. And if you need to leave, you'll be hearing back from me. You'll get a recording of this video and the CEU form again. But we'll be able to stay on here for a few more minutes if anyone else has a question.
Looks like Drew unfortunately had to log off, but I guess, yeah, follow up with me if you have questions later. You know how to find me. Here, I'll even type my email address in the chat. And let's see here. I also sent a link, put a link in the chat for the Trees and Lawn Canada book, if you're interested in that. All right, I don't see any other questions, and I don't see any other hands. So I think Carla, we've taken care of everything. Unless anyone wants to, any last takers.
Well, thanks so much for your time, James. Thanks so much, John, for joining us. Thank you to everyone that were able to come. You'll be hearing from me. I will be sending out the link again so you can submit your CEUs. You guys have a great rest of your day, and we hope to see you at the next learning series. Bye, everyone.